Papers. So my name is Raquel, Aldana, and I have the honor and privilege of serving as the Associate Dean for Faculty Scholarship here at Pacific McGeorge, and also the honor to moderate this panel. I think initially our idea of putting the Natural Resources panel and the Space panel in the afternoon is to juxtapose the idea of space as an area to exploit or explore. You choose the word that you'd like to use when you think about space, but also the area of natural resources, which is an area I think that most of us would agree has come to perhaps a consensus that we are facing over-exploration, an area of exploitation to the point where scarcity and the real possibility of significant consequences to our planet has made us really think about how private property or the law of property should regulate in this arena. We conceive of natural resources primarily as a public good, right? So what role do private actors have in that regime? And states in regulating the acts of private actors, and for the good of whom, right? For the public good, how do we define that? And at one point, does private uses conflict with the public good? And so this should be a very, very interesting panel. And we have, we're going to start with Professor Jacquelyn Jampolsky, I apologize for that, who is currently at the Getches Wilkinson Center for Energy, Natural Resources, and the Environment. She holds a JD and PhD degree from the University of Colorado, both from the law school and from the Department of Environmental Studies. She spent 3 years as the legal extern for the Native American Rights Fund, where she assisted on cases in all areas of federal Indian law. So her perspective would be focused on Indian law. She's got a new book coming out on energy poverty. And she's currently, as I mentioned, working as a fellow at the Getches Wilkinson Center for Natural Resources. So we'll hear from Jacquelyn. Next, we're going to hear from Tom Antkowiak.
Very good.
Polish.
Another tough one.
I know.
You got a tough panel to pronounce.
From Seattle University School of Law, and we decided that we just had to meet. We have a lot in common because I litigated before the Inter-American Court of Human Rights and just realized that when I represented one of the clients, he was working at the court, and we both worked on the same case. As he alluded to, he's going to be focusing on the Inter-American human rights system and specifically how the Inter-American human rights system has been utilized to advance indigenous rights and reparations in several key cases. And ultimately, though, he brings an interesting critique about the court's approach to indigenous people's rights. Next, we're going to hear from my colleague, Steve McCaffrey, who really is kind of the demigod in international water law. He's done so much, and I'll just mention a few things. He was a member of the United Nations International Law Commission since from 1982 to 1991, and he chaired that prestigious organization's 1987 to 88 session. And served as a special rapporteur for the International Law Commission's draft articles of the law on non-navigational uses of international water courses, which formed the basis of the 1997 UN Convention on the subject. And I think we just celebrated an anniversary of that, didn't we, a while ago. My favorite part about Steve, both because he's doing so much, and he's so humble, and he travels so much. And my favorite story about him is the fact that he's represented Nicaragua in a lot of the disputes with Costa Rica involving water. And I must say that I have a soft spot for Nicaragua because I've been there. And even though I love Costa Rica as well, I like vulnerable people, and I like the fact that you represented Nicaragua in these water disputes because that's good. And then finally, I must say that it's such a delight to have Rachael Salcido as a colleague. I mean, she, as you know, has been responsible for organizing this panel, and she's always incredibly active on the faculty, really pushing for engagement on really deep issues. And she's so passionate about natural resources. And, you know, for example, she's currently active in the Rocky Mountain Mineral Law Foundation, has done significant writing in this area. And I will say that I guess my favorite story about Rachael is our partnership with this idea of going to Guatemala this summer to look at corporate social responsibility in the context of practices by primarily foreign corporations and extraction or uses of water and hydraulics and also the absence of regulation of natural resources in that country. So we're hopefully going to do that and maybe come up with a co-edited book, and I'm really looking forward to partnering you on that. So with that, we're going to turn to our speakers and we'll begin with Jack. Thank you.
Okay. Find the right presentation here. While I do this, I would like to say thanks for everybody to have me here, and just to correct a few things. I wish I was as great as I was made out to be in that introduction. However, I do not have a new book, just a chapter in a book, and I'm not yet a professor, although I strive to do all of these incredible things as my colleagues on this panel are doing now. Okay. So you heard a little bit about my background. I think a little bit more framing about the school that I come from will help with this panel. I did the JD and PhD at the same time, and my committee was made up half of geographers and half of lawyers. So maybe to respond a little bit to some of the themes brought up in the last panel, I'm really steeped in this interdisciplinary framework and mixing theory, rich property theory, and doctrine, because I think that's where the most exciting strategies come from. So I hope to do a little bit of that in this presentation, and I know that we're the last thing between you and lunch, so let's get started. My presentation today is entitled Making Resources, Making Management, and we are going to start at the very beginning. So although concepts of property and management have been around since time immemorial, property as a legal construct, right, is relatively new. We talked about the works of John Locke, and really historians haven't been able to find much literature about where property comes from prior to him. So this was in 1690, and of course his famous work of property in his two treatises of government, where we all know he argued that God gave the world to men in common, right, and that individuals could secure ownership over land by working it. This is true and in the context that he speaks, but it's really important to ground that in what he was speaking against or about, right? So he started writing kind of at the peak of the British enclosures in England. This is a nice, pretty pasture, British countryside. This is what it looked like. But starting in the 14th century, the wealthy class began to fence off parcels of land because market capitalism, right, also a relatively new concept, was just beginning, and international markets were budding, and wealthy people fenced off parcels of land so that they could convert them to pasture, raise sheep, and sell wool, sell commodities. So property really came out of this issue, right? It had a dual function of securing the rights for wealthy class to kind of exploit their individual parcels, and also as a protectionist mechanism through government to kind of prevent from total exploitation, right? We have all these horror stories about the tragedy of the commons and this and that, and property was really posited as this necessary function for preventing man to do what they are proposed to do, which is destroy everything, right? So Locke and Blackstone, and consequently the common law of property, really comes out of this framework. And the point of this is that property and markets grew hand in hand, right? It is the fundamental bundle of rights that it is ownable, alienable, fungible, comes out of making resources into something that can be just that. So any understanding of property and environmental management today has to acknowledge these processes, right? There's something that we do through the law and through the context of management that create resources as properties that we can manage as such. So the point of this being that I want to try to have people let go of any assumption that there might be that resources exist in nature, that property exists as something outside the context of management at all, as means to kind of break down the doctrine, use the theory to kind of regenerate some new strategic thinkings about what management means and how we can do that better, and for what purposes. So I did my dissertation with the Ute Mountain Ute tribe in southwest Colorado, and I worked with them on developing their integrated resources management plan and cultural resources management plan, which didn't exist on the reservation before. This is a federally funded project, and really got to work with them on turning this, which is this large interrelated landscape, to something that looks like this, right? So now we have endangered species habitats, we have groundwater, we have surface water, you know, tribes of state, TS is a tribes of state provision of the Clean Air Act, solar energy sites, cultural sites, right? All of these really rich individual things, resources that need to be managed. So I argue in sort of engaging in these processes that to make properties, or to make resources conform with the fundamental tenets of property, alienability, fungibility, ownership, you have to engage in three major processes. The first one is visualizing, right? So we have this really large landscape. You see something different than what you see here or on a map. This picture is of us documenting some cultural sites. So these are ancient Puebloan lands. People have been there for a very long time. And so when you see these sites on the landscape, it's kind of hard to cognize what those are. They're very old, lots of ruins, but basically you go based on archaeological theory that the traditional nuclear unit had a kiva, a great room, a midden, a trash dump, and a large room block. So when you go documenting these sites, you use your GPS and you drop a point at the center of each kiva, and then you find another kiva and drop a point. And then you use technology to kind of amalgamate these lines into districts. And so once you do that, now you have this kind of large landscape which you're not entirely seeing what's going on there, and it now looks into a nice, neat cultural site that's presentable on a map. So that's your first process. The second one, I argue, is separating and classifying, right? Distinguishing the difference between properties. This is a picture of one way in which we did that. You collect pottery shards, and then you look at them and you say, okay, this one is with mineral paint, this one is with plant-based paint, this rim of the pot is hatched instead of smooth. And each one of those techniques is sort of thought to be of a particular time period. So you count them all up, you do statistical analysis, and then you date the site. So when you date these sites, you say, okay, this is from this time period and not this one. So when you present this to the National Historic Preservation Board or something of the like, you can identify it as, you know, a particularly old site or a newer site, which grants different protections under the laws. So the third process, the one we're probably most familiar with in how property plays out daily, is valuing, right? And this doesn't necessarily mean assessing monetary value to each thing. It could be assessing priorities internally with the management plans that we worked on. You know, you have to say, okay, this could generate a lot of money through a solar site, but it also is home to, you know, sort of these really important spiritual or cultural sites that we would like to prioritize over money. So those are the three processes that I sort of identify as being essential to creating resources as a product of management, which happens through the process itself. So on the one hand, this allows tribes, okay, this is my particular area of expertise, but this would go for states, communities, anything, not just tribes, to engage in resource management cognizable by the state, you know, sort of broadly construed, because you have to engage, as we said, in this legal framework to be recognized under the law. So that affords certain valuable protections and also funding opportunities, for the tribe that I was working with, getting grants that, it's in the middle of nowhere, and these are governments that have to provide for a community and provide jobs, and so federal grant funding is really important. But on the other hand, engaging in these processes sort of is antithetical to the way many Native communities view the landscape. I think that we could say that it's antithetical to a way that a lot of us can view the landscape, right? We don't see it in terms of, okay, this is surface water, this is groundwater. We see watershed. And that's not to romanticize the fact that every Native community doesn't believe in property, because that's just not true. But if you want to consider resource management as a tool to protect certain things for tribes, then you have to ask the question, well, if this is necessarily effacing your traditional ways of seeing the land, why do you do it, right? And tribes are savvy, communities understand all of this. And so there are other reasons why, in my experience working with tribes, nobody really had any sort of ideals that these plans would necessarily do much at all to preserve resources from their perspective. But there is power in property, and there are other reasons why people might want to engage in the framework. So sort of trying to root this in some doctrine, one of the major reasons why tribes do it is to engage in off-reservation management, right? So I'm not sure what the general understanding of Indian law is here, but the reservation system was one where large communities were kind of shrunk and dispossessed and put onto smaller parcels of their traditional homeland, and if at all a part of that. So they're really confined by the boundaries of the reservation and how they can engage in management, particularly with the state. So when you start to look at creating resources as a way to kind of have a juridical hook into engaging in some of these management processes outside the reservation boundaries, it becomes a really useful tool, right? So now we can engage with co-management agreements with the state, because the state can look at your resource management plan and can recognize that you have cultural resources outside the reservation and say, okay, let's make an agreement. Let's have you help us manage this forest, what have you, because maybe you are actually better stewards of this particular parcel. I talked a little bit about cultural sites, NHPA proceedings. This is anybody who's going to conduct a project on federal lands has to abide by certain federal laws, the National Historic Preservation Act being one of them, which requires consultation with tribes. So if you can definitively identify a certain cultural resource being yours, okay, this is a Pomo burial site because it involves all of these different things that only our tradition came with, then you can use that to say, this project on this federal land is going to potentially implicate these cultural resources, which are really important to us, so you need to consult, period. In California, this is becoming more interesting because there's a new groundwater legislation, right, which not only recognizes a tribal federally reserved right to groundwater, but requires that tribes be a part of any management plan that affects a groundwater basin that might implicate their rights. And CEQA was recently amended to also include sort of a tribal consultation provision within the CEQA amendment. So now, through these state laws, tribes are able to kind of jump into powerful circles of management in which they would be precluded from without being able to identify the resources that way. So bringing this back to the international theme of the contest, and I hope that this is a good segue into your presentation, this is important for land title, right? Land title cases require maps. You know, you have to be able to say, this is my land, this is what you're infringing on, this is what you need to recognize. And this necessarily engages in the same processes that we discussed before, which can be really problematic because, you know, representing this sort of static polygon in front of a court leaves so much out and might actually harm how those processes and pathways normally work. And then finally, this is an interesting thing I just want to highlight. indigenous peoples have been able to use this process to secure damages, right? In the case of Saramacca versus Suriname, this was a title case. Traditional lands were granted to multinational oil companies, which destroyed a lot of their traditional timber reserves. And when they calculated damages, you can read in the decision, they didn't just say, you know, timber is worth this much money on a market. They said, okay, these are your traditional practices. There's a whole bunch of intangible value that we're associating with this timber reserve. And so the community was able to demonstrate this to the court through a community map saying, all right, this particular tree is used for this particular purpose, and the court should, you know, honor that when assessing damages against the company. So the major point here is that recognizing that resources are and can be created and recreated through management frameworks hopefully opens up new strategic conversations about management goals. For Native people, this means making complex choices about how to best protect their natural and cultural lifeways within the broader legal framework of the state. And in sum, resource management isn't just about protecting resources. It's about property, fundamentally, and it's about power, and it's about rights.
See if I can find my PowerPoint now.
I think we should close that entirely in the right. Yeah. And then there you go.
Good, thank you. Great, thanks. Sorry for the shameless plug earlier, by the way. Whenever I hear the Inter-American Human Rights System mentioned, I just get so excited. I want to talk about it, I want to engage, and I'm really happy to see that Professor John Sprankling is also engaged in the Inter-American System in his very important book. And it's great to hear about the Saramacca precedent from earlier. Just a couple of things before I get started on my focus for today. So what is the Inter-American System? And again, I think that this really picks up on what we were talking about just a few minutes ago in terms of whether the international human right to property can permeate national legal frameworks. And I think the Inter-American System is a perfect example of how it can do so. Now the question is, and what I'm going to close with, is that there are certain drawbacks to the court's conceptualization, right? And so how those conceptualizations are eventually welcomed and legislated in the states of the Americas. But in case you aren't familiar, the Inter-American System, we're talking about the Americas, right? We're talking about the states of the Organization of American States. And in terms of an instrument, we're talking about primarily the American Convention on Human Rights, which has been ratified by 24 countries in the Americas. Surprise, surprise, the United States is not among them, right? But what it does is it actually offers one of the strongest property formulations among human rights instruments. If you compare it to, for example, we were talking a bit before about the Article 1 of the Protocol to the European Convention on Human Rights, or if you look at the Arab and African charters on human rights, you'll see that, yes, property formulations are there, but without an express right to compensation, among other omissions. So the American Convention is interesting in that, first of all, it sets out somewhat robust right to property, and we don't really have time to get into all the nuances and pros and cons of this particular articulation. But what I'd like to do is get more into how the Inter-American Court, which is the highest authority in this region, has interpreted the convention, and in particular, the right to property. Okay, so it's been a very broad notion that's been advanced by the court, both intangible, tangible property. Yes, there's intellectual property. Some of you who know just a bit about the Inter-American Court think maybe it's all about forced disappearances, right, and horrific human rights abuses. Yes, it's seen its share of those cases, but again, the cases are being really diversified in recent years and seen some sophisticated problems dealing with intangible property. But from my all intents and purposes, I'd like to focus on the indigenous right to property and tribal property and indigenous property that's been developed by the Inter-American Court in a really novel way since the key case Alice Tigney from 2001. Why am I interested in all this stuff anyway? Just to give you a quick background. I've been involved in cases, so I'm also a human rights attorney. I've been involved like Raquel, but without her full trajectory and distinguished background. But some of the cases that I was involved in hit right at the heart of this matter, right? The Moiwana case versus Suriname, which actually I think I might have heard mentioned a little bit earlier, dealt with an Afro-Latin population in Suriname. They were driven off of their lands. 39 individuals were massacred when governmental forces suspected this particular community of being aligned with an insurgent group. You can see here, these are members within the Juka community in Suriname. And that particular monument in the bottom commemorates the massacre. So this case that I worked on dealt directly with these issues, and I'll talk a little bit more about that in a second. We've also been involved in representing indigenous communities in the Peruvian Amazon. You can see here in this image, you see gold mines encroaching on the Peruvian Amazon. We were representing these communities in the Inter-American Commission to try to shore up the legislative framework in Peru to give these communities not only the right to consult, but to be consulted, but more. Okay, and then finally, and I was just talking with my colleague here about the Nicaraguan Canal. If you guys haven't heard about this, because it's actually been very few and far between, you can find this in the press. We're talking about a $50 billion project that's deeper, wider, and longer than the Panamanian Canal. Of course, it's running through collective territories of Afro-Caribbean communities and indigenous communities, and it can cause environmental disaster. So my clinic right now is working with indigenous groups, Afro-Latin groups in Nicaragua through the Inter-American Commission on Human Rights to try to stop the construction of this canal until these communities are not only duly consulted, but until they issue their consent for the project to continue. Okay, so I talked about Alice Tigney, this watershed moment in international human rights law with respect to property. And this is, again, discussed in the book. What we're talking about here is the court's recognition that, I quote, there's a unique and enduring tie that binds indigenous communities to their ancestral territory, right? And then the court further specified that this relationship should be understood as the fundamental basis of its culture, spiritual life, integrity, and economic survival. Now, the Moiwana case that I just referred to, that was important because it took this framework one step further and applied it to tribal populations, however you'd like to define that term. But in this particular case, we were talking about Afro-Latin communities that lived in the jungle in eastern Suriname that had proven an all-encompassing relationship with their collective territories. So as a result, they also recognized communal property rights without any title, right? Or without even any legislation in the state of Suriname that recognized collective forms of property. Okay, so starting with Alice Tigney, as I said, this is novel development. This ruling was a first for international human rights tribunals. Okay, and the European Court of Human Rights, we were talking about that earlier, hasn't come close to a comparable interpretation, although, you know, arguably it's had its opportunities with the Sami people in Scandinavia. So since that particular interpretation of Alice Tigney, we've seen a rapid development and a reception of these principles in international human rights law. UN human rights institutions, the African Commission on Human and People's Rights, along with others, have taken up these principles of a communal right to indigenous and tribal property. Okay? So what is this actual standard then to activate property rights in this context? Well, it's, according to the court, if communities have occupied their lands in accordance with customary practices. Okay? If that's the case, then they're entitled to official recognition. Again, no title necessary, and it doesn't even matter if those communities have a current possession of their lands. And of course, this is in recognition of forcible removal and displacement of indigenous communities since time immemorial. So how's petitioners satisfy this standard? Submitting anthropological testimonies, their testimonies, of course, other experts. And surprisingly, in the half dozen cases that have been litigated before the Inter-American Court, states really aren't offering much expert opinion and evidence and contrary. So the court hasn't denied these claims. And so it's really fascinating because the court will, and if you're not familiar with the court's remedies, the court goes structural, individual, and communal. So the court will order widespread legislative reform in countries, overhaul of legislative frameworks so that communal property rights will be recognized. Not only that, but of course there's the lands themselves that are at stake, and there's been cases involving the Chaco in Paraguay where 41 square miles of territory have been given back to indigenous communities. They've won these cases outright. Again, the state hasn't really vigorously contested these points up till the present time. Now, this of course calls to mind the question, well, what is the minimum amount of custom, right, that a community needs to show to a court in order to activate its communal right to property? Right? Are we essentializing these communities? Are we freezing them in time? What if they want resource extraction on their lands? What if they want to adopt the newest forms of farming technology? Will this jeopardize their collective rights to their lands? Okay, so we'll come back to that in a minute. We've talked about how these rights are recognized in the system. But the question is, can they be restricted? And of course they can. I mean, we've heard all morning long how the right to property is not absolute, right? It's often conditioned, and you can see here in the American Convention, it's the same as in many other formulations. You can subordinate such use and enjoyment to the interests of society for reasons of public utility, et cetera, et cetera. Now, in the case of indigenous communities, the Inter-American Court goes a little further and says states, wherever there's restrictions, these restrictions cannot constitute, I quote, a denial of traditions and customs in a way that endangers the very survival of the group. So what a relief, right? A state can't endanger the very survival of a group. Sounds like a kind of a low bar, right? Not exactly encouraging. And how has that been translated in the court's jurisprudence, in particular in the court's case law? Well, these are the safeguards that come out of the Saramaka decision that we just heard about. Okay, the state must ensure effective participation, a reasonable benefit for the community, and an impact assessment, which is social and environmental. Okay, now generally the effective participation refers to a good faith duty to consult actively with the community. Okay, but with regard to large-scale projects in a community's territory, the state is actually obligated to obtain the free, prior, and informed consent of the community. Okay? But if you look at the safeguard framework, you can see that there's some crafty states, or really any state, can evade these principles, right? Because if a state, say, talks to the community, consults with the community about a project coming up, then conducts some form of impact assessment at its leisure, right? And then even provides that community with some form of benefit. Then the state or the private company that it's associated with can then basically ignore all of that information and go on with the development project or the resource extraction. And even in the sense of obtaining consent, right? That sounds like a pretty strong principle, right? And for consent to be achieved, we're talking about the most or the large scale projects, right? But consent is kind of inadequate too, right? Because what if it's a small scale project, but it still destroys a sacred site? Okay, that could have devastating consequences for the community, right? But it wouldn't be protected under a consent framework. It wouldn't be protected. And if you think about it, what is free consent anyway, right? scholars like Karen Engel have written about this. Is free consent even possible in the indigenous context with all the economic coercion that goes on with these projects? And I can tell you that my colleagues in Nicaragua report to me that governance structures of indigenous communities are being subverted by the Sandinista party. They're going in and they're actually replacing leaders, legitimately elected leaders in indigenous communities or Afro-Caribbean communities, with essentially cronies that are going to support the policies of the Sandinista government, which of course is fully behind the construction of the Nicaraguan Canal. So does that mean free consent? Right? So the safeguard framework is limited, right? And even consent has its doubters. Now, in 2012, there was another case, which is pretty much the most recent case dealing with this matter of resource extraction in the Americas, called Sarayaku versus Ecuador. And in that case, the court almost takes a further step back, and when it talks about the safeguards, doesn't even really give full discussion to the idea of consent at all. Okay, so it seems like not only are the safeguards not strong enough, but they're kind of in decline in the current case law of the Inter-American Court. All right, so what's my critique here? Where do I think we should go with this? And I'll be interested in your thoughts on this, because I have a feeling that it may not be readily welcomed by some of you. But I guess what I'm thinking is that these safeguards, no matter how you try to strengthen or bolster them, they're going to still run into the same limitation, which is they're under a property paradigm, right? What's the worst that can happen if these safeguards are run over by a state that wants to develop lands in an indigenous region? It'll result in a property violation, right? So when property rights are violated, oftentimes compensation amounts are often pretty low, right? The Inter-American system thus far has been an exception, but there's no guarantee that reparations won't be maintained at that level, okay? And then, of course, I said before, states haven't been defending themselves that vigorously yet in the Inter-American system. What happens if they start getting all the expert analysis in and really challenging this topography, right? These cultural analyses that are advanced by the indigenous populations? There might not be a right to property violation at all, right? The court, like many tribunals, the European Court of Human Rights included, is very deferential to states when it comes to land use determinations, right, and expropriation in a human rights context. So I'm disturbed because what I'm seeing is, over time, as I analyze these indigenous rights cases, not only in a book that I'm working on, but on a previous article that kind of looked at this line of particular indigenous rights cases in the Inter-American system, what the court is doing is retrenching in the right to property. That is, it's kind of locating all these key indigenous norms: self-determination, non-discrimination, cultural identity. It's really effectively protecting it all under the right to property. And to me, that sounds like an untenable proposition. The right to property is fatally limited. I said before, the right to property is a strong formulation in the Inter-American system and in the American Convention. It's still not strong enough, right? States routinely intrude upon the right to property. Compensation is limited, right? And so what I'm hoping, what I argued in a previous article, I don't have too much time to get into this thesis right now, but I'd be happy to address it more with questions, is I think that there should be a shift, not a paradigm shift, because that's nothing I'm worthy of, but I still think there should be a shift, right, from a property framework, trying to protect lives and livelihoods of indigenous people under a property framework, right, and moving it to a right to life framework. Okay, and so there's this interesting principle in the Inter-American Court's jurisprudence, but it's also been adopted in constitutional courts in South Africa, India, and then throughout Latin America, and I was talking to Matthew about this earlier, it's this idea of vida digna, or dignified life. And it's a broad right to life principle. And so what I argued in this previous article was that I believe that many of these important rights should be actually protected under a right to life framework, because we're talking about truly a collective right to life, right? When we're talking about these developments and intrusions upon indigenous and tribal lands. And so I think that that would increase protections. And again, I don't want to get into all the details because we'd like to hear from all of our panelists, but I'd be happy to talk more about that theory at another point. So thank you very much.
Good morning. It's still morning, everyone. Like others, I'd like to thank the organizers, especially Rachael, Salcido, my colleague, for putting this together. I'd like to thank John for his wonderful book, which has inspired us all and brought us together here to discuss some, what I think are extremely interesting concepts and implications of the international law of property. I'd like to talk a little bit about the human right to water. And Anna this morning earlier said that human rights are hegemonic, that this is a very powerful, emotionally powerful thing to label a right. And I agree with that. I tend to agree with that. So the question is, what are these rights, if you label something a human right? How are they realized? Are they realizable? And so that's what I'd like to talk a little bit about today. John discusses the human right to water in his book in chapter 7, and he says a growing body of international law acknowledges that the right to water is a basic human right. And he says that the duty to fulfill the right to water is non-justiciable at this time. Perhaps it's not definite enough, but he says that it's nearing justiciability. And I essentially agree with these conclusions. As far as property is concerned, this is an aside, I'm not sure you can own water. It's part of the hydrologic cycle. And no matter what you do, you can't destroy it, nor can you really keep it. You can keep it in this bottle for a while, maybe, but it's very difficult to own. But that's an aside. I'm not going to go further with that right now. John looks at some of the case law in the human rights institutions in Africa, and I think that probably forms the basis of his conclusion that the human right to water is moving toward justiciability. So I'm not going to talk about justiciability. What I'd like to address is where the rubber meets the road. Implementing the human right to water, realizing it. What's going on there? So human rights law, I think we all have a general notion of, but I'm not sure about that, so I thought I'd just say a couple of words about it. We've heard references to what weren't really called human rights earlier, but you have the French Declaration of the Rights of Man or Humans, and so forth of the 18th century. You have inspiring language in our own Declaration of Independence and so forth. But in terms of a coherent body of law, we really didn't have human rights law as we know it until after the Second World War. We had international humanitarian law, which developed in the latter part of the 19th century, but not really international human rights law. The UN Charter, of course, adopted in 1945, speaks of human rights in its preamble. Fundamental human rights. I mean, one could say that one of the main forces that led to the adoption of the Charter was not only the desire for the second time in the century to end war, but also to stop what became known as genocide. That's another concept, legal concept, that was really unknown until the Holocaust. And we as an international community then decided to try to deal with that. There are developments in human rights law, but most fundamentally, it was designed to protect individuals against abuses by their governments. And then, of course, economic and social rights go further and guarantee certain kinds of living conditions for individuals. All right, water. Water and life. We're constantly looking on other planets, even asteroids, for water. Why? Well, because that is an indicator that there may be life there, may have been life at one point. So it's kind of ridiculous to think that water is not the subject of international human rights law, right? I mean, it's the most fundamental thing. Air is fairly fundamental. Water is fundamental, more so than food even, which is mentioned in the instruments. But the International Bill of Human Rights says nothing, zero, about water. This is rather remarkable if you think about it. You don't have to think about it much, right? Nothing in the Universal Declaration, nothing in either of the 1966 covenants, right? Civil and political rights, economic, social, and cultural rights, about water. Now you might say, well, it's implicit. Of course, because you couldn't realize any of the other rights without water. Well, fine, but why don't they say something about it then? Right? These are all based on the assumption that individuals have access to safe water. Well, no, it doesn't say that. But in 2002, a little belatedly, perhaps, the Committee on Economic, Social, and Cultural Rights, which is the committee responsible for overseeing the implementation of that covenant of 1966, adopted what's called a general comment. And both of the committees, the Human Rights Committee, which oversees the implementation of the Civil and Political Rights Covenant, and the Economic, Social, and Cultural Rights Committee, can adopt these general comments. And they're generally interpretive guides to the respective covenants, and these committees can use them when they are grilling representatives of states who get up before the committees periodically and report on their compliance with the relevant covenant, okay? So you can bet that this general comment 15, is going to be drawn upon by the ESC Committee, Economic, Social, and Cultural Rights Committee, in their dialogue, let's say, with state representatives who are reporting on their compliance with that covenant. Okay? It stated that there is a human right to water and that it's derived from Articles 11 and 12 of that covenant. 11, adequate standard of living, including adequate food and housing, and 12, the right to the highest attainable standard of health. So it's a derivative right. That's not very satisfying. It's a derivative right. All right, well, we'll take it, right? Okay, good. And in the covenant, in the general comment, the committee lays out what it means. In some detail, I've just captured one paragraph here, and I'll only read the first sentence. The human right to water entitles everyone to sufficient, and think about these words when you think about what it will take to provide water, safe, acceptable, so it's not brown or something, physically accessible, and affordable. Water for personal domestic use. Okay then, yes, that makes sense. A right to water makes all the sense in the world. It goes without saying, you might say. And the way it's defined, yeah, that makes all the sense in the world. The problem, however, is when you think about it, the economic, social, and cultural rights guaranteed in that covenant can't be just switched on like a light switch. They take some work by the government to guarantee, to actually develop and implement, right? For that reason, unlike the civil and political covenant, whose rights must be guaranteed immediately, right? The right to life, which really means the right not to be arbitrarily killed. That's what that means, classically anyway, it's developing. Unlike that, the right to water, any of these, the right to sustenance, standard of living, you can't just implement that immediately. It takes some time. So Article 2 of the ESC covenant recognizes this, and it says that you implement these rights progressively according to available resources. So, and when you actually look at the language of Article 2, it's even weaker. The parties undertake to take steps individually and through international assistance and cooperation. And I'll come back to this language, by the way, so keep that in mind. Individually and through international assistance and cooperation, especially economic and technical, to the maximum of its available resources with a view, take steps with a view to achieving progressively the full realization of the rights recognized in the present covenant. So, by recognizing that the right to water is derivative of these other rights, the Economic, Social, and Cultural Rights Committee has said states have to do this, basically. That seems reasonable. But what about all the people who are suffering from the lack of access to any safe water at all? Suffering from waterborne diseases. And there's this statistic about children dying from waterborne disease. So they do not have safe access to safe water. Well, no problem. We have the concept of core obligations, which means these are obligations that are at the core of the relevant right that must be implemented immediately. Furthermore, the committee defined core obligations to mean basically everything that they drew as implications of the human right to water in General Comment 15. And they're all of immediate effect. And I'm not going to go through these because I don't have time, but if you go through them, you'll find that virtually every aspect of the human right to water that's identified by the committee is mentioned in these core obligations. In other words, states have to realize them, implement them immediately. Well, obviously this is important, but can you really ask a developing country to do this immediately? No. And again, I will skip over this lightly. The committee says, for the avoidance of any doubt, basically all the rich countries have to enable the poor countries to do this. and they quote from the language that I mentioned in Article 2. And I don't really think this is serious. I don't think you can just impose an obligation on someone that can't, as a practical matter, be fulfilled immediately and say, well, you need to fulfill it immediately, and the responsibility for assuring that is with the rich countries and donor institutions. I think one of the results of this is healthy skepticism on the part of some of the most important countries in the world, and certainly some of the most important donor countries, and I've listed a number there: US, UK, Australia, Denmark, Japan, Netherlands, Canada, and our own state. Remember when Governor Schwarzenegger vetoed the right to water, human right to water legislation? It was watered down, brought back to Governor Brown, who signed it. These are just examples of what countries have said. The United States says there's no right to water and sanitation in an international legal sense. The UK says no sufficient legal basis. It's not part of customary international law. What are the developing countries supposed to think? Right? I mean, these rich countries, the U.S., I suppose, again, now we're the richest country in the world. I don't know. We don't guarantee the right to water to some of our inhabitants. But anyway, how are we supposed to expect, or how is the international community supposed to expect developing countries to guarantee this right? Major countries, yes, don't think it is law yet, and there are people, now this is not what this is supposed to do, who cannot understand this explanation, and these are just a few. You can Google women in water or children in water, and you can find lots of images like this, walking tens of kilometers every day to fetch water. This woman has access to an improved water source, but she still has to carry the bucket. I hate to leave you on that note, but I think I'm out of time.
That might be Porterville right now, or
it could be.
Number of
it could be.
Cities in California.
It could be.
Carrying a bucket.
Thank you very much.
So I'm going to remind you that this was supposed to be right before space law, because I know that actually Wayne and I are talking about something a little similar even. When it gets to that later, I'll, let's see, where am I? This was as close as I could get to looking like the ocean, so I think there probably are PowerPoint templates that have the ocean, but this is as close as I got. I think my presentation is going to be really echoing Jacquelyn's, and so I was very hopeful that I would get a chance to speak after her, and thankful to all of my panelists who were willing to step up and swap space, or time actually, with the intellectual property folks who we'll hear from this afternoon. But I really felt like I needed a bit of time to tell you that there's still a commons out there. John Sprankling notes this when he talks about the high seas. So I'm going to talk to you very briefly. And I am mostly going to, I think, not elaborate on my thesis that I'll give in my paper, but I'm going to just give a little bit of information so that we have plenty of time to have questions from the panelists. So my essay itself will discuss the regulation of ocean space under international law, with particular emphasis on the threats to sustainability, increased industrialization of the oceans, and the prospects for reforms that would address declining ecological health. And I posit that an international law of property could help to provide support for proposed reforms that emphasize the shared nature of ocean resources and collaborative conservation measures tempered by consideration for the needs of current and future generations. I mentioned I'm not going to do too much to give you all the support for that, but I will tell you a little bit here that when we look out into the world of natural resources, we've kind of put up these walls to propertize, right, things, to capture their value, and that never really matches the ecosystems or kind of acknowledges the interconnectedness of wildlife and people and water, watersheds you mentioned. When we look out into the world, we don't always see, why did they put the highway there? Why did they put Highway 37 across that beautiful marsh? So one nice thing, though, about the United Nations Convention on the Law of the Sea is that it did seek to provide a comprehensive blueprint for ocean regulation. And in the preamble, it notes itself that it was conscious that the problems of ocean space are closely interrelated and need to be considered as a whole. So this was something in the minds of the drafters, that all of these different issues related to the sea, why are we separating land and sea? Again, another problem for us, but it is what it is. And although the United States is not a party to the convention, we do recognize it as customary international law. We are at a disadvantage here and there in certain instances, but one thing we do claim is the largest exclusive economic zone. The United States is an island nation. So as John's book points out, the Law of the Sea Convention divides up these areas of ocean space, and I think environmental law professors usually either show you pictures of horrible things, pictures of beautiful things, or maps and diagrams. So this, I think, helps to explain very well that while we have the territorial sea, right, this is just kind of conceived of as our property on land, right, so the greatest sovereign rights here, and the right of innocent passage. There are some rights that others privileges that they enjoy, but this is to be seen, this territorial sea to 12 miles, as sovereign territory. And then here, the exclusive economic zone is not territory per se, although the nations enjoy sovereign rights to the water column and continental shelf. And then out here, the high seas, this is an area where there are no national rights. And this is where I mentioned, we don't have an extended continental shelf claim because we're not a party, but other nations have made claims. So the high seas is, for all intents and purposes, right, still a global commons, and which actually turns out to be kind of challenging. So my paper will largely focus on that and the proposals that we're seeing now to make an adjustment to the high seas area. So I want to note here that a lot of what has happened in the Law of the Sea Convention, creation of the area, supports John's thesis. We've moved from an open system to boundaries, increasing nationalization of ocean space, both with the shelf and the water column. And yet the high seas represent 60% of oceans, and it's not under the national sovereignty of any nation. And I would say, as an environmental natural resource professor, we're often skeptical of private property rights. They often stand in the way of our desires to make changes to traditional property uses. But I think as I pursued this thesis, I found some hope in some of the changes that are being proposed, and maybe a reason to embrace the international law of property. So takeaway point here, the regime supports Professor Sprankling's assertion that an international law of property has emerged, I would say in particular in the creation of the authority, an international body, supranational authority that vests title to minerals in contracting parties, the area here. So any private party supported by a government can apply to mine the deep seabed area, and that vests property rights once those minerals are extracted, not through any sovereign nation, but through an international body. So I felt at least I needed to get that information to you. The piece I won't go through much here is I'm very concerned about the state of our oceans. It's been something I've studied for many years and written about. As in my piece in 2008, I talked about industrialization of the oceans. I just finished a co-authored research agenda with colleagues from the UK and Spain, Australia, looking at the legal rights necessary to implement resource use here, marine renewable energy, because we have lots and lots of open questions about how that will play out, what kind of rights, what kind of usufructs we will see being employed by different nations. If you look at the types of laws that are on the books in many nations that govern the exclusive economic zone, they are largely directed towards the exploitation piece and not very much towards the conservation piece of things. So we see many people then agitating for a few solutions, and I would suggest that these could be looked at, maybe as Anna pointed out, in property theory, looking more to a public trust doctrine in the ocean, which kind of recognizes that sovereigns may be limited in the way that they use these public assets. Even though they're sovereign rights, there may be limits to the extent that we can exploit those. And then the other piece that I think is important is the push throughout a lot of nations are doing this. The United States has really moved towards ecosystem-based marine spatial planning. Again, the fences that we talked about, setting up these management areas. And largely, so I'm gonna go all the way here. Yeah, that's it. We're looking towards a new high seas agreement on marine biodiversity. We're actually recognizing that leaving this area open as an open access commons has a kind of great impact on biodiversity. Less than 1% of the high seas are covered by marine protected areas where there are limits to fishing, etc. And we want to move on this before significant resources could be lost. What else did I say? We show you pretty pictures. This is the Great Barrier Reef, an example of a marine protected area. Thank you.
We have a few minutes for questions. I'll start with Brian.
Steve's really painted a very dismal picture, I think probably accurately. And I'm thinking that what you're talking, what others have been talking about have been what I would call negative rights, and what you're talking about is positive rights. And the notion of positive rights is very new. It's in the South African Constitution and the Indian Constitution. I don't know how many others. I think certainly not in the United States Constitution. The Supreme Court has been very clear that there are no positive constitutional rights, and I'm just wondering how you fit this into sort of the development. Do you see a development of positive rights internationally, or whether we're going to basically see continuation of a regime of negative rights, which is what most of the of both domestic and constitutional and international instruments guarantee?
Yeah, well, thanks, Brian. That's it's a very good question. And the covenant recognizes this, as I say, progressive implementation, progressive realization, takes steps. It's very cautious, but then the committee comes along and says, yes, but there are certain core obligations that you have to guarantee immediately. And I think they went overboard, and I think by doing that, they're frightening some countries, especially the ones that you can't afford to frighten, because they're the ones that are going to be giving development assistance to the developing countries. so that they can realize these rights. You mentioned South Africa. They do have a constitutional provision guaranteeing the right to water. However, the Supreme Court of South Africa has held in the Mazibuko case that it's still only to be progressively realized. So exactly, this requires positive action, not refraining or abstention from, let's say, extrajudicial killing, as the Civil and Political Rights Covenant does. So it is going to take time. But my quarrel, I guess, is in saying, okay, there's a human right to water, instead of saying, look, we really need to come together as an international community to try to help states realize this right. And some of you, by the way, like the United States, should work harder with your available resources to make sure it's realized, because there are people in this state even who do not have access to water. They have to buy bottled water. And so, it could have taken, I think, a more constructive approach. That I think is the bottom line.
I'm going to actually use my moderator prerogative and follow up with a question, because I wanted to, what I was thinking about, especially with your presentation, Rachel, that followed Steve's, is both the reduction of the right to water, which really we mean potable water, to a human right. To me, everything that you talked about was about human consumption and access, in contrast to the idea of preservation. And you really can't have access without preservation. But it struck me, right, that also is, even if we conceive of a right to water, it is primarily conceived of as a right for us to use it and exploit it, and not as what is the relative in terms of commons, in terms of public good. It's not there, and I think it would be a more robust conversation, because even when you talk about developed nations and their responsibilities, one of them for me is, well, we'll consume much more water, right, than the rest of the world, and maybe the way we contribute to access is by really having a regime of conservation that comes from the international community about, okay, let's take a look at how much water you waste as a regime that we ought to regulate as a way of guaranteeing access. My problem with the way you framed it, or the way the international community, because you were just sort of describing that, is that it seems to be sort of artificially separated. So access and preservation not being discussed in the same way.
Well, there are a lot of water-short areas in the world. We are in one of them right now. And that's driving conservation and efficiency, which is natural and normal. Developing countries do need assistance to achieve this, however, because not everyone can afford drip irrigation, for example, or the so-called, sorry to say this before lunch, toilet to tap measures that have been taken, wastewater,
Or the basic sanitation that impacts the ability to, tap into resources or, water that might otherwise be available, that all of these things they're connected.
Sorry, Jerry.
So two questions. The first is a follow-up to yours and Brian's as well. Even if we conceive of the right to water as a human right, how are you proposing that we implement this? You can't even think about using a treaty in its ordinary form if that obligation requires developed states to help developing states, because we can't just then depend on national systems to enforce that. So that's the first question. The second one goes to the panel more broadly. We're talking international law here, but then we're referring to some select tribunal like the Inter-American Court, right? Is that truly international law when it doesn't represent customary international law? And why are we saying, when we point to these decisions, that they should be the law? I mean, it is, after all, only those particular nations that are bound by the obligations set out under that particular convention that's being adjudged, right? And so why should we look to that as defining the standard? It's easier, right, when we have something like the law of the seas, where we have a majority of the international community on board, but I mean, it's far more problematic when it's narrower and split into multiple tribunals.
Shall I can be brief on the first one? International assistance really is helping with the implementation of, I don't know whether you call it the human right to water or just access to safe water. There's a lot of drilling of boreholes going on in the developing world, financed by countries like Denmark and Sweden and so forth, and the United States. USAID is doing a lot of work in that regard. So we're getting there slowly. But my quarrel is this unrealistic idea that it have to be implemented immediately. I'm sorry, you can't, you know. And so, is that going to be used in various international, perhaps even national tribunals, to accuse water agencies of not doing their job because they aren't implementing the human right to water immediately? I mean, it's fallacious to me. I think the second question.
Well, I just want to follow up kind of on this conversation generally, and I think that sort of a fundamental assumption of this is that states, right, nation states are the best organization to implement this right. And that really assumes a benevolent state, and from my perspective, you know, most of the litigation that I work on is against the state, you know, and so in saying that that's going to be the solution and that private rights to water are necessarily detrimental to access, especially minority access, which is what we're talking about, I think is a little bit problematic and important to at least, you know, conceptualize a joint regime here that might mitigate some of those forces.
I might jump in too, just to get to Jared's question about the impact of one particular regional human rights tribunal upon the rest of the formation of international law. And that was one of the reasons why I wanted to hone in on rights with respect to indigenous communities and tribal communities, because I think that that particular strain of jurisprudence by the Inter-American Court has been picked up in large part by UN Human Rights Committee, right, which monitors the implementation of the International Covenant on Civil and Political Rights, which has been ratified by approximately 180 countries. It's also been directly followed.
Even us.
Yes, we've even ratified, believe it or not.
Somewhat belatedly, 1994, I think.
Took us a while. Also, the African Charter on Human and People's Rights, I'm not sure if you guys are aware, has actually been ratified by every state in Africa, 53 nation states, talking about over 1 billion people. Okay? And so, both of those regimes, the United Nations, International Civil, and the ICCPR regime, and the African regime, and then other regimes to a significant part as well, have directly adopted some of these principles from the Inter-American Court. So I think in that sense we are seeing the emergence of a global phenomenon with respect to those particular points of law.
How about, this might be addressed to you two guys, the desal plants as a way to provide water. And it seems like you let the cleaner water go into the ocean and mix with salt water, and then you want to take the salt out of it and put it back on the land or let people use it. Why not capture it before we have to get to the desal stage?
In-stream uses? I mean, you know, I think,
well, there's water treatment plants, right? And we have those. We know how to do that. Right. They're expensive.
They're building one, I think, in Monterey.
These. I'm not talking about desal. I'm talking about just water treatment plants, which are expensive. Desal is even more expensive because it takes a lot of energy to shove that salt water through the reverse osmosis membrane. But Israel
entrainment of I mean, even the technology that we kind of finally have, I guess, which now has the pipe kind of coming in at an angle, but doesn't bring in as much sea life and entrain the sea life against. I mean, these are big industrial facilities, like, you know, power plants on the seashore, right? So
that's one of the problems, though. If you don't have access to the sea, if you're landlocked, it's hard to desalinate unless you're taking water out of the Aral Sea.
Or the Great Salt Lake.
To the extent it exists, the Great Salt Lake, yeah.
John.
I just want to point out that there is some connection among pieces by Jacquelyn, Thomas, and Steve in particular with respect to the concept that recognizing the rights and natural resources of tribal indigenous groups does include water. And of course, in an era of huge water scarcity, it's not very helpful. But certainly in some areas where you vest autonomy over those resources in the indigenous tribal, depending on how broadly we define that. And Thomas in particular talked about the movement from indigenous to tribal, which could be a much broader world. And you think about how that would apply, say, to Africa, for example, under the convention. It raises some really interesting questions about why don't we mitigate some of these issues, at least prevent them from getting worse, by vesting control over water resources in a tribal or indigenous group in an area where there's at least marginal enough water now. It doesn't deal with the jumbo jet. I was startled by that statistic, Steve, in arid areas, but there's some overlap, I think, between the presentations that you're making.
Yeah, no, I agree.
I was at a water conference recently also where the Groundwater Act was raised, and it was a chairman from a tribe who talked about how important it was that local governments worked with the tribes, that that they wanted partnerships, and that we should be looking at ways that we work together.
I have several questions or comments. All of it's just tremendously interesting. But on the current discussion, Peter Diamandis, who founded the X Prize that led to Bhutan's suborbital flights, he's written a book called Abundance, and he's taken an unexpected approach to a lot of things. If you think about Africa, who would have predicted 10 or 15 years ago that so many people in Africa would own cell phones? A lot of the solutions to having adequate, healthy water are big infrastructure projects. He talks about a technology for a water filtration system that would be affordable by an individual village. And that to me seems like a very promising approach because it's lower tech, it's lower cost, it's something that might spread as the price comes down. So I think it's something worth looking at and thinking about rather than taking a big infrastructure approach.
Yeah, solar distillation is another thing you can do on the micro level.
Yeah, I think that might be a promising way to go, just the more individual approach. I find the situation in the Arctic tremendously interesting, and I'm wondering, under the law of the sea, now that the Arctic ice is melting, and Russia and Canada and Denmark and the US are jockeying for position for how much they will claim of the ocean floor there. Have you looked at that, and how much of that is right now is technically considered high seas? Do you know?
I haven't looked at that. Have you, Steve?
Well, Santa Claus is okay, except there's no ice to put his igloos or whatever he lives in on anymore. But he is on the high seas or on the North Pole. But yeah, I mean, both because of the extent of the exclusive economic zones, of which is 200 miles, right, from the coast of the polar countries in the Arctic, and because of these extended continental shelf claims that Rachael referred to. Russia's making one, which initially went all the way over to Canada. And I don't think the Commission on the Continental Shelf has actually approved that. But
the U.S. I think was collaborating with Canada to try to define our areas.
But we can't make an extended claim because we're not party to the Law of the Sea Convention.
So ultimately, it'll probably be negotiated.
Hopefully.
And then one other comment. I don't know that we have time for discussion, but I have to say.
I have two more people, so I'm sorry.
Oh,
I'm going to make sure I get two more at least. Yes, Frank.
Okay, I wanted to return to the first two papers, which got me thinking about a comment. The property is in some sense relational. We've been focusing on the thing, but it's also the person or persons, and that's in some sense, who makes decisions about the use of the thing and their right to do so without interference from other persons or persons who might make a conflicting use or claim to the thing. And while we tend to start thinking about an individual's, a human being's decision about property versus perhaps a government control, in fact, what we get in the first two papers are groups of people, something that historically was surmounted in European history by the creation of the corporation, whose primary purpose was to allow groups of people, whether that was city, towns, churches, and other groups, not just business corporations, to control this thing. And then you get the question about, well, who within that group is deciding about the control over the thing? But once you group it and corporatize it, then the question is, the government is simply another group of people who are making decisions about the thing, and why should a smaller group necessarily have triumphant rights over the larger group with respect to the thing? Just I thought that was interesting. Came out of the sort of papers, especially about indigenous rights.
You some kind of communist?
We've been accused, right, Frank?
Well, I think that
No,
Rachel's comment about the tragedy of commons is a practical answer for that.
Yeah, and I think it will be interesting. I mean, one of the, from a conservation point of view, there's research that shows if we close the high seas to fishing, we would have larger fishery outcomes in the exclusive economic zones than if we just continue to fish all across. So if this is the idea behind kind of marine protected areas, et cetera. But I mean, if that's that is literally closing off, right, this open access area. And so as they're trying to kind of balance this traditional freedom of the seas, to recognize that what are the costs of continuing to let anyone, right, fish in these areas with the migratory nature of these fisheries. Tuna, right? We still like tuna. Sharks, etc.
Yeah.
I mean, I'm not sure that I necessarily buy to the idea that there are these things that are ownable by individuals exclusively at the expense of others. I think part of what I'm really interested in exploring the technologies by which we identify properties is working to identify them in different ways. A group right to property, communal rights to property is not this foreign concept. I think that at least my experience working in the United States, that is different depending on what community you're in. The concept of a tribal government is not something that's universal across the 565 federally recognized tribes that exist here. Many don't have a centralized government and never did. And I think maybe a practical way we can think about this, if we're going to tie it into land claim cases, is when we make maps, rather than trying to identify a static polygon in which you can present as evidence, maybe there are ways to map shared spaces or, seasonal uses. And I think once we open that up, then there are some really productive ways where you can say, all right, this property right does not necessarily have to be exclusive of this one. And I'm really curious about how we can do that in the future, because we can't just fight for.
Kojo, I am so sorry, but we are out of time, and I know that Rachael in particular is very interested in keeping us on schedule because we have a very important lunch program coming up, so I'm going to let you kind of tell the crowd what's next.
Oh, okay. So, you're right. Okay. So what's next is, I believe, lunch is right outside the door, so please grab your lunch, and we're going to begin at, 12:45, back in here with Dave Littlefield and John Sprankling, so see you back in 10.
Yeah.